Yes, we will study. Today we will study MSW32, Block 2. Block 2. So I will show you. Yes, MSW 32, Unit 2. Unit 3, sorry. Block 3, Unit 1. Block 3, that means Book 3, Unit 1. In this unit, we see, in this block, we see investigation. Unit 1, investigation and prosecution process. Then trial process, Unit 2. And Unit 3, correctional process. And Unit 4, juvenile justice system. These are the 4 units which come under Block 3 or Book 3. First of all, we can see police and investigation of cognizable offences. Police and investigation of cognizable offences. In Police Act 1861, it is clearly stated that also in Section 2H of CRPC, investigation. What is investigation is described in Police Act 1861 preamble, also in CRPC Section 2H. Investigation is explained. That is for the collection of evidence conducted by the police officer by any person who is authorized by a magistrate in his behalf. It is a way of words. It refers to systematic and procedural way of collection, collation, comprehension of facts pertaining to the crime. That is investigation. So the police is authorized or empowered through Section 156 CRPC for what? To conduct investigation in cognizable offences. In cognizable offences. The officer in charge can arrest a person without arrest warrant. So judiciary is not supposed to interfere. That is, police officers and above the rank of a head constable. Now, in ancient times, it was head constable. Now, civil police officer and grade SI. This head constable is called grade SI. Police station can investigate cognizable offence. As per Section 2O of CRPC, the police is authorized to investigate. So, if it is when it is referred to a cognizable case under Section 156 CRPC, so when you write these sections are very important for examination, without which you won't get marks. It is defined under Section 2C of CRPC as cognizable offence as an offence for which and cognizable case refers to a case which police officer may, in accordance with the first schedule under any other law for the time being or force, arrest without warrant. You simply bear in mind that cognizable without warrant. Non, whenever there is a non with warrant. Non with Must remember that. Non-cognizable means with the warrant. Cognizable means without warrant. Police can arrest a person. Uh, because non-cognizable offences are very silly matters. I had told you earlier. Under sections 2021 of CRPC, a magistrate is empowered to entrust investigation to a private person also for special for special reasons. He can entrust the investigation to a private person also. Then we come across when we come into non-cognizable offences. Non-cognizable offences. Only one person, isn't it? Non-cognizable. So what is non-cognizable? I told you, uh, you can arrest a person. That is, under section scheme of CRPC, the police are not vested with the powers to investigate non-cognizable offences on their own volition, and non-cognizable offences are considered to be petty. So without warrant, they cannot arrest. So order is a must. Order from a magistrate is a must to arrest offences, non-cognizable cases. The competent magistrate orders so in writing. Then, Section 155 CRPC has categorically laid down that if any person furnishes information to an officer in charge of the police station or commission of a non-cognizant offence, the police officer shall cause to be entered the substance of the information in a book. Station goes direct. He has to record it whenever he gets an information. Then what? The police cannot go and arrest a person. I have told you, without the orders of a magistrate. So non-cognizable, the phrase has been explained in section 2.1 of CRPC. So here, the police officer has no authority to arrest without warrant. No authority to arrest without warrant. Section 155.2 of CRPC that no police officer shall investigate a non-cognizable case without the order of the magistrate. It is specifically mentioned in section 155.2. You have to, when you study for your exam, you have to make a short notes that is non-cognizable without arrest, no arrest without warrant. Section 155.2 CRPC. Then these are cognizable and non-cognizable offences. So it may be violation of Article 21 if the police officer arrests a person in non-cognizable case without a warrant. Article 21, right to life, right to live. It is the most important article. Hence, the persons can move to the court. Then there are territorial limits of the police to investigate recognizable offences. So, jurisdiction will be fixed. That is, the police can arrest a person without a warrant within the jurisdiction of that police station. Within the jurisdiction of that police station. This often gets confused to the clients whenever something happens or some crime is there. If it is in a border means where the jurisdiction of one station ends and the jurisdiction of other station begins. And if the person belongs to the first case, and if he has committed the crime or if he died only in the jurisdiction of the next police station, usually the police will say, it is not our case, the jurisdiction comes to that police station. And they may argue that the police station, that police station has no other license, he doesn't come under their jurisdiction. These are all the things happen in our society and we see it. That is, a jurisdiction can receive, compliant and register case and investigate. Framing of charge. Fair trial in criminal cases is to give precise information to the accused as to accusation against him. As to the accusation against him. Fair trial in criminal cases to give precise information to the accused as to the accusation against him. That means, fair trial, the accused must be uh, informed of his crime, accusation against him. Accusation. What is the accusation against him? That is to be made known to him. So, in the case of procedure, the case of serious offences, the code requires that accusations are to be formulated and reduced to writing with a great precision and clarity. Then what? Framing of charge is explained, enumerated in 228 of CRPC. What is charge? Section 2D of CRPC explains charge. Charge includes any head of charge when the charge contains more heads than one. That is, charge is explained into section 2D. Then, so without framing a charge, uh, the procedure is what? Incomplete. So once when the charge is completed, it has to be framed and presented in the court of because he doesn't file it or charge it. What the court may alter to any charge at any time before judgment is passed. So sometimes he may be convicted, sometimes he may be acquitted. That depends. Then framing of charge in trial before a court of session. Court of sessions court means sessions judge means criminal judge, criminal case. If upon consideration in the record of the case, the documents submitted there and after hearing the conditions, the accused and the prosecution in this behalf, that is, the judge is of the opinion that there is ground for presuming that the accused has committed an offense. So, if the magistrate feels so, that is, as per the documents submitted. Section 2, 227 of CRPC. Section 227 of QRPC. That uh, and exclusively trial by the court, we shall frame in writing a charge against the accused. That is section 228 1, class 1. Or subject. That the purpose of 27 and 28, that is 227 and 28. 228 of the court is to ensure that the court should be satisfied that the accusation made against the accused person is not frivolous, but it is of correct and it is true and if it is genuine. This stage, uh, in this stage, prior to the filing, the court should be satisfied that the accusation made against the accused person is not frivolous, means silly, and there is some material for proceeding against him. Hence, court must feel so. Section 20, 227 and 228 are interrelated and should be read together. That is, framing of charge in warrant cases by magistrate. That is the police report and the documents sent with section 173, the examination of the accused, if any, and hearing the parties, the magistrate is of opinion that there is ground for presuming that accused has committed offense. Tribal under 19 of the Code of Criminal Procedure. So, the police files and charges and submits before the magistrate. But it is not the case. The magistrate should feel that it is correct as per the documents he has committed the crime. And hence, it is correct. Also, the magistrate should be competent. You know the word competency. Competent. Competent means having the authority. Here, here means having the authority. That is competent. So the magistrate can move without authority. Then section 240, which is 1. Section 173, as per documents in section 73 before framing charges. requires a magistrate to consider the documents. The police will submit the documents, but he has to consider the documents because the magistrate should feel that the documents are correct and right. Consists the records investigation which are not admissible in evidence at the trial but can be made of limited purpose as stated in section. That is section 240. Then guidelines for framing charge under section 239 and 240 of CRPC. So in this stage, the magistrate is required to consider whether to discharge or to frame charge. That is the stage in which magistrate is required to consider whether discharge to frame a charge is of vital importance both to the prosecution and also for the accused. That is, he has to consider whether it is important or not. There are some guidelines which the magistrate must follow and comply with. So otherwise, they won't be accepted. The guidelines are explaining the charge to the accused. That is, it is the duty of the police or the court authorities to explain the charge. Explain to the accused and shall be asked it whether he pleads guilty of the offence charged or claims to be tried. Section 240. Motor vehicle accident cases. So what will you do? When there is an accident, a small vehicle between a small vehicle and a big vehicle, that means scooter and car or bus, then uh, the owner of the hire vehicle is held responsible. Normally, usually and generally. Even if it is the mistake of small vehicle, owner of small vehicle, then what will happen? So the fault may not be the case of the owner of the big vehicle, four-wheel vehicle or car or some other heavy vehicles. But the fault or there will be fault in the part of the scooter, small device. That is scooter, small vehicle. That is scooter or something like that. At that time, the police will tell, as you guy, even if it is not your mistake, you accept it, so that that person gets gets insurance. So if that person charges, if the police charges a case against the owner of the big vehicle, that is an example I am telling. Even if he is not guilty, it will be charged so because the person of the small vehicle may be responsible for the accident. At that time, the owner of the small vehicle has to get the compensation from the insurance. The owner of the big vehicle has to accept it, that it is his crime. Otherwise, he won't get. Usually, normally, generally, it happens. So, otherwise, he won't get the benefit. Usually, it is done so. Then only he will get the compensation. Usually. So, Charge at that time the charge should be read, and the owner of the big vehicle will be wondering because so many classes will be written there that carelessly driving and without minding other vehicles, overspeed, and so on. Actually, you might not have done all these things, but when the magistrate reads, it is seemed that you are guilty. Do you accept it or not? So, if he doesn't accept, the case will continue, and it is his duty. The burden of proof is with him. Usually, it will be with the burden of proof will be with the plaintiff. Now it is burden of proof will be there, and he has to prove it. Who the owner of the small vehicle has to prove that that person has committed a mistake. So if he denies, the case will continue. The owner of the big vehicle says, "No, it is not my fault." Then the case will be continued, and finally the judge will see whether the vehicle of the big owner or small owner who is responsible for the accident. So there are clauses like this. In warrant case, a magistrate is competent to pass an order after a charge is framed. Charge is framed for acquitting or convincing, for both acquitting and convincing. Convicting, accused or convict. Then, so whenever a charge is framed, once the charge is framed, the magistrate has no authority to dismiss it. Uh, Once the charge is framed and the complaint is there in a warranty case, the magistrate has no legal authority to dismiss the case or dismiss the you know dismiss the case even after framing a charge. He has no authority. Then points to consider important are no judicial jurisdictional error means that is whenever a case is filed, two things will be considered. First thing is the court has to accept in file. That is, the application will be filed. They will accept it in file. Accept it in file. That is filing the petition case in court of law. So at that time, the magistrate or the concerned legal authority can reject it. That is, during the filing itself, the petition can be rejected. How and why? But if there is any technical error, that will be rejected. For want of the cost, prescribed cost. That is a certain amount has to be remitted as fee in the court. And if it is not done properly, that is enough fee is not there. Then for want of a jurisdiction, that is the case never comes in that jurisdiction of that magistrate, then the case will be. Then other technical defects, that means it is unsigned, not having properly are filed are not signed by the advocate, and so on. So many technical errors are there. Then there is the second point, second level. That is what I have described hereafter. The second level is verifying the locus standi. Now, what is locus standi? Locus standi means considering a petition, considering a petition before a court of law with enough law point that is reason or cause to accept. Legally correct application. But if there is no if it is not legally correct, if there is no point to frame a charge, or if there is no legally accepted points to accept that application, and if there is no locus standi, means there is no law point in that, uh, as per law, this application cannot be accepted. Then that will be. So now you understand the two important points by which a petition is rejected in any court of law. Okay. One is technical and other is locus standi. Here so many cases are referred. Charge should be on the basis of material on record. These are the points. That current practices and procedures for withdrawal of prosecution. That is, the public prosecutors will be having pressure to withdraw the case. Who is a public prosecutor? He argues for the state. He argues for the state. That is, the state will, the public prosecutor has to appear for the state. And if he is pressurized by various forces to withdraw the prosecution, because high profile persons are involved. In Unique Carbide case, this happened. And in Best Bakery case, this happened. In such cases, in those cases, the Supreme Court interfered and ordered a retrial because the public prosecutors are not willing to continue the case. That's it. Withdrawal of prosecution. Indian Code. Section 321 enables the public prosecutor to withdraw the case. I can tell you a very clear example. Whenever a political party is in rule, one political party in power, so cases will be charged and framed against persons belong to other political parties. In so many issues, cases will be uh, charged, framed, and charged and filed. Cases will be filed. So after their tenure, if the other party comes in power, what will you do? What will they do? They will ask the public prosecutor to withdraw those cases because it is the state which files a case against such persons. So now they are in power. So they will ask the public prosecutor, their public prosecutor will be there. They will ask them to withdraw the case. So the public prosecutor will submit an application in the court of law stating that government is not willing to continue the case. Hence, that will be ഞാൻ ക്ലാസ്സിലാണ് ക്ലാസ് കഴിഞ്ഞ് വിളിക്കാൻ പറ്റും ക്ലാസ്സിലാണ് So usually the public prosecutors will be pressurized to withdraw the case. But in some serious cases, even if the state wants the public prosecutor to withdraw, and as such the public prosecutor's request, the court will not allow in some serious cases to withdraw the case. Some public property uh, destruction and so on. The court feels so, they won't allow to withdraw. The court will not be letting, will not be giving for what chance to withdraw. Section 321 enables public prosecutor, assistant public prosecutor in charge of the case to withdraw from prosecution. Then conditions for withdrawal. So it should be done by the public prosecutor. He must be in charge of the case. Then the withdrawal from prosecution can be sought at any time before the judgment is pronounced. Then primary objective of section 321 appears to be reserve power to the executive government. The government has the power to withdraw case. The duty of the public prosecutor is most important. That is under section 321, the public prosecutor and not any executive authority who is entrusted by the code with the power to withdraw from a prosecution. It is only possible through public prosecutor. The duty of the court. The court has wide discretion whether it is to be withdraw or not. Withdraw or not. Because the court at times, I have told you, may not allow the public prosecutor to withdraw. Here comes the locus standi point. De facto complainant has no locus standi in the matter of withdrawal from prosecution against the accused by the public prosecutor. It is therefore not necessary for the court to issue notice to the complainant to afford hearing. That is, the court also enabled the knowledge of the court to appreciate decision on the application of the public. In exceptional cases, whereupon case the party the party interested in proper administration of justice may even challenge a decision of the court granting sanction. For what? Withdrawing the case. The effect of withdrawal of prosecution. The withdrawal from the prosecution is made before the charge has been framed. The accused shall be discharged in respect of such offences. Then there will be no offence against the accused because the case itself is not there. Then how can be there an accused? There will be no accused person because his charges will be removed once the case ends. That's the. Then victim compensation scheme. So victim usually will be given compensation. Section 357 of A of a principal code, that is CRPC, section 357. So one thing has to be reminded in this time, has to be cannot but be referred, because in the ancient times the money was not given to the, so, or we can say compensation was not given to whom? The victims. But as a policy change, the court itself felt so, and the laws completely changed. Uh, and the victims need help. So the court ordered for a compensation. And as per law, the victim is eligible for compensation. In some cases, serious cases, for example, a rape case and molestation and such cases, the magistrates order the accused persons, or the judge will be like that, an amount apart from imprisonment will be there. That amount has to be given to the victim. That amount has to be given to the victim. In most of the cases nowadays, it is so. Okay, it is. We can see that in so many cases. You might have come across this issue in media. In media, in so many cases, the compensation will be also declared along with the imprisonment. So also there may be some adequate facilities for rehabilitation of the victim, because the victim is there and nobody is to take care of the victim. It is the duty of the state to protect the wealth and security, to protect or to give protection and for the life and wealth of the people. That is vested with the state government, and hence the victim also should be uh, protected. Then power of police to arrest restricted. That is CRPC Amendment Act 2008 becomes effective. The police, instead arresting the accused, will be obliged to issue him a notice of appearance for any offense punishable with the imprisonment up to 7 years. That is, for example, the case is filed and if that punishment for the case comes below 7 years, that is up to 7 years, that means not more than 7 years, a notice is to be given before arrest. So there is a case against you in the station. You come and seek application, give application for bail. You can, you will get bail if only you come and apply for a bail in a court of law. So if the person doesn't come, he will be arrested. So if it is above 7 years, the procedure is different and there will be no notice. The person will be taken into custody. That's all. That's all. This amendment was done in section 41 of CRPC. Under section 41, originally issued, the police officer may, without an order of magistrate, without warrant, arrest a person who has been concerned in a cognizable offence. That was amended. D.K. Basu versus State of West Bengal. This important case. Now we pass on to this I have told you, that he can withdraw at any time case as per the request of the government. We can withdraw the case. Now we come to unit 2. Now we have finished only one unit, and now comes the second unit is the trial process. Here, stages of criminal trial, constitutional rights of the accused, procedural safeguards to the accused, the right to the legal consultation and legal aid. These are the points discussed. This trial process. So what's in the trial process? Trial, you know very well. When a case is filed and evidence is collected, charge is framed, and FIR ready, and it is submitted before a court of law. And if it is a bailable offence, bail will be given. And if it is non-bailable offence, what will be done? This criminal will be put under judicial custody, or he will be remanded. That's the procedure. Then, preliminary stage conducted by the police. That is what is called investigation. That is after recording of FIR. The officer in charge of the police station suspects the commission of an offence from statement of FIR or what the magistrate directs otherwise. If the police officer feels so, or if the magistrate orders, I don't know, to spot to investigate facts, that is circumstances of the case, and if necessary makes sure for discovery and arrest of the offender. That is investigation. Then inquiry. That is inquiry. Inquiry means consists of a magistrate after receiving a report from the police upon a complaint by another person being satisfied of the facts. Okay? ഞാൻ ഒരു ക്ലാസ്സിൽ ഇരിക്കുകയാണ് നാളെ വരുമല്ലോ ഓക്കെ ഓക്കെ that is a warrant case relates to offense punishable with the death imprisonment for life or imprisonment of term exceeding 2 years. There are two types of procedures. What warrant cases were? Trial by magistrate, those instituted upon police report, those instituted to complaint. That is trial by magistrate. Then if it is instituted on police report, it provides for the magistrate to discharge the accused of upon consideration of the police report and documents sent with it. Then the magistrate hears the prosecution and takes the evidence. If there is no case, the accused is discharged. And if the accused is not discharged, the case will be continued. That is, the case will be continued. A summons case means, I will tell you clearly the difference between summons and a warrant. Summons case means summons is only a notice issued to a person who has done a crime. Summons. You have to appear before the court on this date. Okay. It is what is called summons. But warrant is, I told you, warrant is like an arrow. Like an arrow sent. If an arrow is sent, that will hit a person. It won't come back. It won't come back without hitting a person. That is why do we send an arrow? To hit some object with the aim of hitting some object. Like that, warrant is issued to arrest a person. Why? After issuing the summons, if he doesn't come, warrant will be issued. You might have heard of so many warrants because high police officials may be given summons to appear before the court. 1 time, 2 times, 3 times, and the officer may not be aware of it, or the junior, the persons concerned may not make him aware of it, or some lapse may be there. And even after second summons, if an officer doesn't come, usually the court will put an arrest warrant to arrest that person and produce before the court. Now you understand what is summons and what is warrant. That's the only difference. Then recording a prosecution evidence, that is all statements will be collected, all evidence will be collected, and that will be recorded by the prosecutor. Section 309 of the CRPC provides that proceedings shall be held as expeditiously as possible in court. Expeditiously means speedy and in genuine manner. When the examination of the witness has once begun, the same shall be continued day to day until the witness in attendance have been examined. Statement of the accused is most important. That will be recorded. He may deny or he may accept in a stage. Defense evidence means the defense counsel will produce evidence supporting the defendant. That is defense. Then final arguments will be done between the two counsels, and the judgment will be passed after the trial. The judge pronounces his judgment in the trial. Hence, it is relevant to mention that CRPC also contains detailed provisions for compounding of offences. Compounded means, we had studied it in the earlier. What is compoundable, what is not compoundable. Then there are constitutional rights of the accused. Presumption of innocence. That means Article 21, right to life, right to live. Article 42, International Covenant on Civil and Political Rights, 1966. Article 11 of the Universal UDHR, Universal Declaration of Human Rights, declares that everyone charged with a penal offence has the right to be presumed innocent until proven. That is what is presumption of innocence. That is if a person is person is charged with a crime. The court in many cases pronounced that no person can be called a criminal unless and until his crime is proved. Unless and until his crime is proved. That is presumption of innocence is guaranteed by the Constitution. The right to fair trial. Fair trial Article 21. A fair trial is there protected in the Constitution. Fair trial means everything should be known to the accused person, and in fair trial he has every right to ask for the copy of the FIR, ask for any detail from the public prosecutor, and if he gives an application for that, the public prosecutor has to give it a copy of it. Right against the ex post facto operation of the criminal law. What is it? No person can be accused and convinced of an offence for an act which was not an offence under law in force on the date when it was committed. That's the meaning of the ex post facto operation of criminal law. That means the person is arrested and charged with a crime. And once it was a crime, and now as per law it is not a crime, then this person cannot be arrested and taken into custody. That is the ex post facto operation of criminal law. That means once the law was there and now it is not there, and for which now that one person is charged with that crime, and it won't be, sustaining. That is guarantee against ex post facto operation of criminal law. Also, no, which did not constitute a penal offence under national or international law at the time when it was committed. In another words, in some other words, I can say another words. That is, a person is arrested for having committed a crime, and he is in bail. He's in bail. Now the government has amended the law, and now what was committed by that person is not a crime as per the amendment now. Then that person will be released. No, nor shall be heavier penalty be imposed than the other that was applicable to the time penal offence was committed. No person shall be held guilty for that. Protection against double jeopardy. Double jeopardy. You know what should be double jeopardy? This can be asked for short question. For what? Locus standi, protection against double jeopardy. These are all things. Double jeopardy means no person can be punished for the same offense twice. That is double jeopardy. For example, a person is charged with a crime and he is punished, and again somebody gives a petition that he is a criminal and he is done with it in any other court of law. This won't. This cannot be accepted because no two punishments for a same. That is protection against double jeopardy. Self-incrimination. That means Article 23. So, is fundamental right of an accused to remain silent to questions relating to the offense alleged against him. That is, if he is questioned, if he remains silent, in silence, this is right, you know. That is, the accused shall not be administered oath. That is, the accused shall not be administered oath. That means, yeah, okay, I will tell, I will question, I will answer whatever you say. No, you cannot be compelled for that. You cannot be compelled for that. Now we pass on to the fourth unit. Second unit, fourth point. Procedural safeguards to the accused. There are procedural safeguards. What are they? Section CRPC explained in detail and also in IPC. That is, at the time of arrest, it is the duty of the police officer. Section 4, and 46 of the code lays down the procedure to be followed to the arrest of person. So it is the restraint of liberty of a person. Then in this context, I have to say one thing. I cannot but say anything. The Supreme Court has given clear-cut proclamation and orders in each and every state to be followed, and it is to be followed by each and every police station regarding arrest. 10 commandments. The 10 points the Supreme Court has given. That is, if a person is arrested, he should be presented before a magistrate within 24 hours. Then medical help. Then to consult a counsel. Then he should be, when he is arrested, it should be known to his immediate relative. Then if it is a bailable offense, then he should be allowed to take bail. Such and such, there are 10 points which Supreme Court has within 24 hours, and it should be intimated to his nearest relative. Also, a copy of the notice of arrest should be given to his relative. These are all the points. That is done. Safeguards against the search of the person, property belongs to it. So, section 15 of the code and 93, 94, 97, section 165 CRPC, section 51(2) lays down that if a woman needs to be searched, the search must be done by another woman officer. That's a must. That is safeguard. Also, bloodly request. Whenever there is an arrest of a woman person, a woman criminal, the woman police officer must be, police should be there. The right against torture, he should not be tortured. If it is so, if it is so, the officer, police officer will be guilty. Right to know the grounds of the arrest. The person who has, I have told you, the person who has the right to know why he is arrested. Right of the accused to know the accusation and what is his crime. And right to bail. These are all things I have told you. Right against illegal detention. So he cannot be detained illegally. Section 56, 7 and 76 of the Code gives effect to Article 22 of the Constitution. He cannot be put in custody illegally. Then the judiciary will scrutinize all these things. Evidence to be taken in the presence of the accused. That is Section 273 of the Code. And right to speedy trial. Article 21. Then right to medical examination, I told you, health and safety. Rights to legal consultation and legal aid, I told you. The accused has the right to legal consultation, legal pet practitioner of his choice, and also free legal aid for an indigent accused. And if it is not possible for him to, for a person to get an advocate, the state, the court will direct the state to give him legal aid by providing an advocate or legal person who is responsible. Then unit 3, we now come to unit 3. Correctional process. That is, once the judgment is given, after that the person, the victim, sorry, the person having gone through trial and court declares him guilty. And the next step is he'll be taken to a correctional home. I told you yesterday, it is not prison, it is not jail, but then what? It is, it is, it is correctional home. That word has been removed, changed. Now only correctional homes. The broader sense. We changed our policy uh, in 2009. This has been changed. A new laws passed, and State Institute for Correctional Administration, SICA, SICA, State Institute for Correctional Administration. That means the sentenced persons, that is, whoever is found guilty, they will have to be put in prison. So in jail. But now there is no word jail or prison. It is correctional homes where there are so many procedures. So if it is not a serious crime, or if it is not, if a person is not punished for life imprisonment, or even if for life imprisonment, he'll be given counseling, and he'll be given training in the proficient area in which he is proficient, to make him efficient. He'll be given skill training, vocational training, and that is done to change his mind from the criminal attitude to lead a life after this imprisonment. So that is reforming a culprit, the convicted person, to lead a very good life and to come back to the society as a good person. That is the aim of correctional homes. I am a faculty in correctional homes in Kerala. Hence, I used to teach the correctional officers. Hence, I know it very well how that thing that is done in correctional homes. I am in touch with those officers and so on when I go for giving the training. So these are all things I have told you. Prison reforms. Prison reforms took place in India. At first, there was a UN guidance for that. National level, an advisory bureau of correctional administration should be established in the central government. The government of India should consider the need for specialized technical assistance. Then state level also establishment of whole time revising boards and mature release. Prisoners for mature release means once the term of his sentence is completed, he must be released, and there will be special institutions for training. That is what is called. Then probation, I have told you. Probation means it is derived from the Latin word probatus, means tested or proved. I think I have told you yesterday. The legal concept of probation as a criminal justice system is conditional suspension of sentence. For example, a person will be uh, will be sentenced for 3 years for any crime, at least for 1 year or 3 years. Then this person will be taken into custody for 1 month or 2 months or 3 months in correctional home. Then, if there is no previous history of crime, and if there is nothing in his family, nothing like that in his family, and if he was leading a very good life, and on my fine morning such a crime occurred, the magistrate will see that the person has no track record of criminality. So he should be, he's a student also, and if he studies, and he may be a promising youth to the nation. So after his studies, he may be able to do many things for the country, or many things for humanity, or many things for community, and so on. So the magistrate will declare that he may be given the chance of probation. That means after 1 or 2 months imprisonment, he will be released. For example, I told you 3 years imprisonment. After 2 months, he'll be released on one condition. Bail will be there, and one condition. There are so many conditions, but that condition is that he will not engage further in any criminal activity. Also, he will not see any criminals, or he will have no connection with any criminality further. And that will be watched by the police, and if the police satisfies that, okay. Otherwise, if he goes and having a very good relationship with other criminals, and if the police reports, the court will dismiss, cancel the probation, and that person will have to undergo imprisonment for the rest of his term, whichever is declared. That is what is called probation. I told you very clearly. The objectives are to make a person capable of uh, leading a life, having a better life in the society. That's a objective. Philosophy is also like that. That is to make him equipped with the capacity to lead a life. There are some terms you may have to understand. The origin and development of Pradesh historical antecedents in US and England, it started there. In ancient times, kings had this pardoning power. Pardoning power means, so if a person is accused and sentenced, he can apply for pardon before the court king. If the king satisfies the country, if the king feels so that he'll be pardoned and the sentence will be suspended, will be given pardon, the right of pardon. Benefit of clergy. Lessening punishment. That is, most writers in the field have accepted benefit of clergy as a primary historical influence. Then recognizance and bail. To recall mind involved in, to recognize the offender has to keep a peace and to recall minding that he was subsequently to appear in the court. When filing of case, that is antecedent. These are all connected with the probation. Development of probation also, India also has this trace back to history in the period of the king. It started in the ancient period, that is, at the time of the king, pardoning power was there, and it was, now you can see, but the president's pardon, it doesn't come under probation. You see. That is entirely different. So you should not get confused with the word of pardon with the pardoning power of the president and that of uh, the kings in ancient times. Because president's pardoning power is invested with him, and it is clearly stated in the constitution. So you might have heard of it. If a person is accused and he is sentenced to death, sentenced to death. So he may give an application for review, and that will be rejected. And he may be waiting for what the punishment done. At that time, as a last resort, our constitution guarantees one thing, and the whoever is sentenced can appeal to the President of India to give him pardon, the provision of pardon, to invoke a pardoning power. That is the it is the discretionary power of the President of India. That is it. Whether it is to be considered or not, because in certain cases, it is the President rejects the pardoning request, then that the pronounced sentence of execution will be done, because if it is rejected by the President, sometimes the President will give a pardon, sanction the pardon, so that that person will be relieved of death sentence, but he may be given life imprisonment, but he won't be let free. You see, he won't be let free. That is, the pardoning power of the president. And now you should have understood the points, pardoning power of the president and pardoning power of the kings of ancient times. In ancient times, that person will be relieved of his charges. But today, the pardoning power of the president, there is no provision for letting him go free. Okay. Then Vishwanath Bhatt and uh, Patankar arrested for committing thefts. Vishwanath Patankar was arrested for committing thefts as he was unable to furnish security. The district officer sent him to a zoo. So he stood surety, but Janardhan Bhatta stood surety for him, promising that he would not again commit theft or any other offense. That is case of Vishwanath Patankar. Then another case is there. So in modern period, before independence, in criminology, the time 1898, section 560 CRPC, the set section was actually taken from the English Probation of First Offences Act. So in that section, it is explained. It was amendment of the CRPC in 1923, which radically changed the law of probation in India. So there's no revision in high appellate courts. No. The period of probation under old section of 1898 was not to exceed 1 year. Moreover, under new section 52 562 of 1923 amended CRPC, a court may grant probation in case of offender not under age of 21 years for offences punishable with not more than 7 years, and in case of offender below 21 years as a woman for offences punishable death imprisonment for life. Do you understand what is that? Nothing. Persons below the age of 21 is allowed. That's all. Given probation, probation chance. Not that. Then so many amendments took place, and government also has done so many changes. Then there is a national law of probation. 1958. Chairman of Hukum Singh was the chairman of the Joint Committee. So the Act provides for different states, different dates for different states, and different parts of the states to apply that. So they will have an opportunity to create necessary infrastructure before the Act is applied. So national guidance came. Then Section 4 of the Act clearly says nature of offence, circumstances of case, character of the offender, and so on. PO means Probation of Offenders Act. No, don't get confused. PO means Probation of Offenders Act. So then it was published. That preamble is to provide the release of the offenders. That's all. Simply mean. Extend and commencement. That is, the Act provides that the Act may be called a Probation of Offenders Act, and it extends the whole of India, except the Jammu and Kashmir. Then There's section 2, probation officer name, description is there. Offenders to pay compensation and costs. So some compensation the offenders may have to give to the court. This stuff which I have told you already. So alternatives to imprisonment. That is, imprisonment is there, but it is an alternative to imprisonment. I told you the conditions. That conceptual evolution of alternatives to imprisonment. So many. There are so many principles. You can see declaration contained 13 principles. Which are they? American Correctional Association 1960. So, what is the ultimate aim of probation? The ultimate aim of probation, allowing probation, letting the criminals go in a probation means changing him as a good person in the society, to change him a person, good person in the society. That's all. Below people uh, below the age of 21, because he will be a promising youth. These are all American probation principles. You must study that. Present law and practices in India. So alternatives to imprisonments are provided. First, Indian Penal Code in various sections. The court has option either to award a sentence of imprisonment or fine. For certain uh, crimes, the court will declare fine of such and such amount. And if the criminal, that person concerned, is not capable of giving the money, imprisonment will be there. In some cases, imprisonment along with the fine will be sentenced, will be proclaimed. Then, if that fine is even then, so if that fine is, if that criminal or accused person is not ready for giving the fine, this sentence will be increased 3 years, then it will be 6 years, because the accused is not ready to pay the fine. Then the court will declare, if he is not ready, if he is not paying the amount, another 3 years or 2 years will be there in prison. That is it. That. Section 360 of the Criminal Procedure Code on order to release on probation of good conduct after admonition. So I told you earlier that is, so if that person releases on probation, is a very good person till the end of his sentence for 3 years or 4 years or 7 years, then it will be okay. But if he engages in a crime, or if he is in connection with any crime, his probation will be dismissed, cancelled. That's the word, cancelled, and he will be taken into custody. Then under 320 of compounding of offences. Compounding offence means there will be no two punishments for a same offence. And if the compounding what I have told you, if that person is not ready to pay the fine, he will be given another period of what? Another period of punishment also. Now, juvenile justice system that is meant for children below the age of 18. Once there was no juvenile system in India till 2006. So after that, juvenile courts were formed and juvenile homes were formed as a result of the amendments. Children are kept there. Whoever commits crime are kept there below the age of 18. Then in international developments, in the case of League of Nations started it in 1924. Then it comes with the UNO, phase 2, phase 3, and after that, UNO took up the case. Then it changed, and then it came to all over the world, in all countries. Development of juvenile justice in India started with the 2006, but actually there were some other laws. That is, Apprentice Act 1850 was the first legislation for children without parent care. Then, between 10 and 18 years, who are convicted by courts should be provided vocational training, that is, apprentice training. That is a way of rehabilitating the children who are convicted. Then Indian Penal Code 1860 exempted all children under the age of 7 from all criminal responsibility because they do not have any rationality, or which they may not be able to find out which is wrong and right. So that's it. Then reformatory schools of 1897. Then Indian Jail Committee 1919 to 20 was mandated with the job of suggesting measures for jail management. At that time, they recommended, and the report was given for juvenile uh, system. Then Children's Act is 1960. These are early legislations. No. Then Juvenile Justice Act in 1986. 1986 was there, but the amendment 2006 was mainly responsible. Influence international advocacy, juvenile system. I have told you the Juvenile Justice Care and Protection of Children Act 2000. Juvenile Act 2000 is a milestone as far as India is concerned. So many amendments came that I have mentioned. But Juvenile Justice Act 2000 is a milestone in the case of India, Indian juvenile system. Uh, so after this act, silent features of the Juvenile Justice Act of 2000 is an important essay. We will take care of it. That is, there will be clear cut, clear cut statements that is below age of 18. Then two categories of children: one who need protection and children in conflict with the law. These are all. Then there will be observation homes. Children in need of care and protection were sent directly to juvenile homes. But if they are violent, not so. They are serious crimes, is not so. Then restoration of the child to family is now considered as a prime objective. Then the mechanisms of Juvenile Act, a walkthrough in the Juvenile Justice Act 2000. Children conflict with the law. They may not accept law. During this period, the child will stay in an observation home. The order states so. Then the Juvenile Justice Board (JJB) will be constituted for a district or a group of district state government to discharge the duties towards children in conflict with the law. Conflict with the law means those who commit crimes. That is conflict with the law. Then there will be observation of homes. The state governments will be observing the homes. Then, on conviction by JJB, the child is sent to the special home. That is juvenile home. There, they'll be separated who need care and protection and finding the child. Any concerned person or organization can produce a child in the need of care and protection before Child Welfare Committee. That's the thing. Now, children homes, shelter homes, uh, in connection with this Juvenile Act, they are okay. The Juvenile Justice Amendment Act 2006, I have told you. This Act of 2000 was amended in 2006. Some important amendments are only said that juvenile, someone who is not completed the age 18, data commission of offense is not is a person is the name of juvenile. Then adoption may be given to person irrespective of marital status. Option to be adopted is available for orphans. From juvenile homes, you know, those who are not having children, they may adopt children from juvenile homes because nobody will be there to take care of the children, and the government will put them in some juvenile homes, and they will be there. So in an age and in a stage uh, in which he was not able to identify what is crime and what is not crime. He might have done some mistake, some crimes, and he will be corrected, and he will be given training, he will be given classes, and he will be given education. And such a child will be completely and entirely reformed. At that time, there is a provision of adoption. That there is a provision of adoption, and people can adopt children from what juvenile homes. Also, childless couples can adopt. Juvenile Justice Act 2000 under Section 60 it authorizes the central government to make rules on all matters which the state governments can make rules. The central government can also make rules which the state government also. uh, Strength of the model rules 2007. Diversion. Principle of diversion, an internationally accepted principle based on the idea that children should be diverted from the formal juvenile justice system through mediation and reconciliation program. Because whenever a child is, the idea behind is, whenever a child is put there or accommodated in a juvenile home, he may have the feeling that he is a criminal. So that will adversely affect the personality of the child or children. So the government's aim is to make them free from that criminal mind. when the idea of criminality will not be there in this point. That is why they may be given adoption chance and so on. Then age rules lays down clear procedure and principles for determining the age of the juvenile under Rule 12. There was clear cut specifically written the age and all that. Then there will be child protection units. Then inspection committee is there, and they will inspect the juvenile courts and the roads and the people and the management committees and everything. Okay. Then social audit will be there. Juvenile courts. As with this, we sum up the fourth unit of block. It's now we completed block 3 of MSW32, and there is one more block which will be completed in the next class. That is MSW32. I have mentioned almost all important points. But I must go through the text in detail because with the simple reading, you cannot write the examination. You go in detail, prepare your essays from the points, prepare your essays from the taking points from the book given to you alone or available in the net. Because to write something here and there, write something from here and there, you won't get marks. Because the person who values your answer book must get an idea that the student has gone through the textbooks very clearly, blocks. Otherwise, you won't get any marks. That is the specialty of IGNOU. IGNOU's notes are very, very good notes, best notes available in the world. Because it is prepared by efficient persons. That's all. So I told you yesterday, when you write your assignments, you prepare it very sincerely so that you will be thorough with the portions for your examination. That is the aim of giving you assignments. Aim behind it, assignments. Okay. So we completed the 4 units: investigation and prosecution process, trial process, correctional process, juvenile justice system. Juvenile is the most important unit in this because what is Juvenile Act? What are the characteristics of Juvenile Act can be asked. Also in the correctional process, also in the trial. So trial is most important. Then investigation, the procedure of investigation, that will be asked. Procedure to be followed for investigation. Then what is prosecution processes. These are all questions which can be asked. Okay. Then we have to finish one more block that will be done in the next class. Then 2 blocks in 30, 1.5 block in 31, MS31, and the last class at another topic. So that we have 3 more classes, 22, 23, and 24. With that, we will finish our portions. 3 more classes are some of you are not present, some of you are very correct, and One or two persons are regular, but some others they came. Most of them came in the first class, but later on they are not seen. No problem. I have to give the attendance. I'll give you. I'll give attendance to persons who are present. But the center is also recording everything. So I think I need not to be specific about it because the center is watching everything and recording everything. Recording whatever is spoken and whatever is seen. Hence it is a record that will be there and you know about you and about myself, the counselor, and so on. So that is about MSW32. So if only you go through the uh, text, you will get the points. Because within these 2 hours, I cannot make you thoroughly understood by all these persons. Thoroughly understand all these persons. I cannot make you understand all points because only 2 hours and 4 blocks are there. I just mentioned the most important points only. All counselors used to do that. Counselors can only do that because within these 2 hours I have to finish a block. Then only the portion will be completed. We will finish the rest of the one block is there. 32. We will finish it in the next class. Okay. Okay, guys. If you have any doubt, you can ask. Otherwise, I will end the class now itself because it's almost end of it. Okay, thank you. Thank you, guys. We can meet tomorrow.
Thank you, sir.